Thank you, Sheriff. Y'all may be seated. General please have a seat, Mr. Wayne. Whenever you and your witness are ready, you may continue your examination. Thank you. All right, call back something. I think you used the term possible active shooter. Do you think this is possible active shooter or an active shooter?
Active shooter. You heard the gunshots. Possible is just something that we normally say just kind of covers in case it might have been something else, but there's no doubt in my mind there's the gunshots.
All right. Talk to you for a minute about an incident that happened 2 or 3 weeks before the shooting. Were you involved in a car wreck?
I was also my wife and son.
Can you orientate us as to when and where that occurred?
It was the afternoon on Easter Sunday, a few weeks prior to this, the shooting. We were Dallas.
We being your wife
and son,
your son.
The Cockrell Hill area, on Cockrell Hill, and the street that starts with a K. I'm not familiar with that.
I'm not familiar enough with that area. Is that outside of Ball Springs?
It's outside of Ball Springs.
And so what city were you in?
It's the city of Dallas.
And where were you going?
We were going to Cockrell Hill to my wife's father's house for Easter.
And what type of vehicle were you and your wife and your son in?
We were in a full-size truck, a Toyota Tundra. Nothing, just good-sized vehicle.
And where was everyone seated in the vehicle?
I was driving. My wife was passenger seat. My son was directly behind me in a rear-facing car seat.
Do you remember where you were when the incident occurred?
We're at the intersection, Cockrell Hill, something starts with a K. One car length. We were either the second car or third car in the line, and there wasn't really a lot of traffic around us.
Let me ask you something. What all was in your vehicle? I mean, was in your wife and your son?
I got off duty 6 o'clock that morning, so I still had all my duty gear. I started my weekend, but got off at 6 in the morning, got home about 6:30, and had time to get everything out when we had to get to the father-in-law's house. I still had all my patrol gear inside my truck at that time.
Well, what would that be?
Either this patrol rifle or the one I had previously, what we call a heavy vest, an entry vest. We wear a Kevlar vest while we're working. We have what we call a heavy vest, which is more Kevlar, and a ceramic plate, so if we come across someone with their rifle, we're more likely to survive it.
Is that a required part of your uniform while you're a patrol officer?
No, that was something that was given to me by the department due to being on the entry team and working with high-risk wards.
So did you have a tendency to wear it when you were out on patrol?
If we got a call of an individual with a rifle, then yes, I would definitely put that on.
Why did you have it in your vehicle?
Because it wasn't big enough to really stay in my locker. So I took everything out of the car, threw it in my truck so I could take it home and secure it there.
And why would you take your patrol rifle home?
Same thing, accountability. Maintain it, clean it, make sure it's serviceable, and I always knew exactly where it was at. Just in case I'm having a station, if we needed to access it, get called in or something, we might not be able to go straight to the station. We might have to go straight to the scene and have everything together in one place.
Well, in the Army and as a police officer, do you clean weapons that haven't been fired just to make sure they're still clean and functional?
Might not be a complete cleaning, but you're going to oil them because the oil will wear off if they're sitting in the carrier. Dust gets down, kind of will dumb them up a little bit, so you want to make sure that they're well oiled and everything moves properly.
So you were at a red light where you stopped?
Yes, we've been stopped for 10, 20 seconds, 30 seconds at the most, enough for me to pick up my drink and turn my head and talk to my wife.
And what was in the drink?
It was an energy drink.
You have a tendency to drink a lot of those, don't you?
That's what I've been told.
What was the weather conditions?
It was not raining at the time. It rained previously, but the roads were wet.
What happened?
I remember turning my head to my right to talk to my wife, and then...
What was Jordan? Not Jordan. What's your son's name?
Tom.
Tom, yeah. What was Tom doing?
Tom was sleeping. He was out cold. He was having a good nap. But then as we're stopped at the light, all of a sudden there's a loud bang, truck jolts a little bit, my energy drink comes out of my hand, and I look up, and there's a car directly behind me.
What was happening in your car? Or in your truck?
My son went from having a great peaceful nap to just screaming, yelling, crying. He was startled, it startled us. It was kind of chaotic inside the truck for him.
How old would he have been at that time?
He was just under 2 years.
Had y'all had a formal diagnosis of autism at that point?
No, it was suspected. We were on the list for the evaluation. It's a long waiting list for the formal evaluation, but he had not been formally diagnosed at that time.
So, the jolt occurred. What happened next?
My kid's screaming in the back. I tell Ingrid to call 911, let them know we're in a wreck. I get out of the car, out of my truck, go to the back door because he's directly behind me. I open the door. My son's crying. I look. I don't see any major deformities, like anything's popped out. I don't see any blood. Okay. She's crawling from the front to the back. She's a small little lady. She being Ingrid, my wife. She's small. She's able to crawl over the console to get to the back of the truck. She's checking on him. So I start moving to check on the people in the car behind me. After I close the door, I still hear yelling and screaming. I'm moving away from my truck, down the back of it towards the television.
Where?
I'm hearing it coming from my truck, but I'm also hearing it coming from the car. So I'm thinking there might be something wrong with the car, but as I'm getting closer to the car and I'm about the back tire, the screaming becomes more audible. Back tire of my truck. It becomes audible. And it was something like, I pushed the brakes, I pushed that from the brakes, it's not my fault. Like, I've worked many wrecks before, I've witnessed some wrecks, I've been able to check on people, and I can't tell what's going on in the car. It's not hell that someone's hurt, it's argumentative type of deal. So to me, that's indicative of, okay, maybe there's a disturbance in the car. Maybe that disturbance resulted into this accident. They weren't paying attention, they were arguing, now we have this motor vehicle collision. So, being off duty, I do have a backup pistol and a badge on.
Would you show the jury where you have the badge and the backup pistol?
I'm right-handed, so backup weapon would be right here. I was always taught to carry the badge next to it. That way, when you see one, you see the other. It's not carried on the other side. They're grouped together in the same location, so there's no mistake of the badge is what they're like.
Is that what you've been taught?
Yes, it is.
Did you have authority to carry a badge and an off-duty weapon outside of your city?
Yes, we are authorized.
So, tell the jury what happened.
All I did was pull my shirt up to display.
How were you dressed?
I was in a t-shirt and shorts.
Okay, go ahead.
As I'm starting to make my presence known, visually I deemed myself as a law enforcement officer.
I'm sorry, what did you say?
As I was visually identifying myself as a law enforcement officer.
What does that mean? Did you tell them I'm a police officer?
No, by displaying the badge, there's basically 3 characteristics that identify a police officer. Weapon, badge, and a uniform with a patch. I didn't have. I was off duty. There's no uniform, there's no patch. I still have the other 2. I'm trying to come away from my truck, get closer to them. They're looking at me, I'm looking at them. Yelling's going on about whose fault it is and what took place.
Were they with the driver of the car or anyone that you...
The driver's the only one I heard yelling. The other passengers didn't seem to be as verbal as what the driver was. But the driver is looking at me and reaching down between the seats. passenger is locked eyes with me and is reaching between the seats. Not sure what's going on. So, pulled my sidearm up against my chest and started giving commands. As you've seen, I'm kind of an animated person, so I'm pointing and giving directions as I go. That way they can hear me and they can see who I'm talking to. If I'm talking to you or you know exactly who it is by who I'm pointing at. So I'm giving commands. Put your hands where I can see them. Put the vehicle in park. I'm not sure what status the vehicle's in. It's running. I don't know what status it is. So there's a couple different scenarios that could have happened. I come away from my truck, walking kind of into the turn lane because I'm in the center lane, trying to get some distance, but I need to see what's in the car. So I come around so I can come up between the front door and passenger door. The gun is up here.
What does that mean to you?
That's in the low ready position, so the position I just demonstrated earlier for you.
And you took it out. Why did you take the weapon out?
To cut down my response time if something was to happen, if they did produce a weapon, if they tried to turn the
Did
vehicle.
you know these people in there?
I've never seen them before in my life.
Was it male, female?
It turned out to be a female.
Passenger? Male?
A female was a passenger, and then two female juveniles in the back.
Did you see them all at one time, or is that just a sequence?
No, I only saw the driver and the front passenger first. I had to come away from the car and back at an angle around it to get full visual.
What were you focusing on when you backed up and went kind of a blade position? What were you focusing on?
Look inside the vehicle, see if I could see what was going on between the two seats. Were they throwing something down, retrieving something? Were they... I'm not familiar with that type of car, so I didn't know where the gear shifters, some gear shifters are on the column, some are down here, so I don't know. Are they going to try to back up and evade? Are they trying to come in a direction that might be threatening to me because there's no traffic? Or are they going to try to go? There's many scenarios. We just don't know. We can't read minds. Can't. Sorry.
Is that a police officer in you?
What's that?
Police officer in you? Can't read minds?
No, it's not part of our training at this time.
So what happened next?
As I approach the car, she's continuing to yell about the situation.
What was the situation?
Stating that it wasn't her fault, she pressed the brakes. So as I can see that she is able to yell, it tells me she's got good breathing. The two in the back, I can see her moving around. There's no restrictions. Doesn't appear to be any visible injuries to the way they're moving. Same thing with the passenger.
Well, at that point, did you have two concerns, what was going on in the car and the condition of the people in the car?
Yes.
Was it a pretty good walk?
It was.
Go ahead. What happened next?
As I got closer and I could see what was going on, that there was no visible weapons. Asked the individual for her identification.
Where's your weapon at that point?
It's still up against my chest.
Did you ever point it at her?
No.
Did you ever point it at her car?
If I would have turned sideways to talk to her, at the A post, it would have been pointing at her hood. But
I thought you'd take the weapon out and point it at her.
no, it was up against my chest.
So what was the nature of the conversation you had with her?
Once I saw inside, I asked her for her identification, her insurance. As I was talking to her, I reholstered the weapon because there's no visible threat that I could see. She had it in park. She complied by putting her hands on the steering wheel. Passenger complied by putting her hands on her lap. So that mitigated, or that really reduced the risk of what was going on.
Okay, what happened next?
She produced a identification card and the vehicle insurance. I informed her that that was the identification card, not a driver's license. And I was informed that it didn't matter.
As a police officer, did you think it mattered? You were in a wreck with her.
Yes. I mean, by law, you have to have a driver's license to operate a motor vehicle.
Did she say she didn't have her license with her, or she didn't have a license?
She didn't tell me either way. She just more alluded to the fact of it didn't really matter what she gave me. It was going to be sufficient.
And was it one of those Texas ID cards that you could tell?
Yes, it was.
That you can go down to flea market or other places, or DPS, and get a Texas ID card.
Correct.
What happened next?
I walked back to my truck to check on my wife and my son. She was on the phone with 911.
She
being my wife.
Okay.
So she handed me the phone. I talked to the 911 operator, gave him a brief synopsis of what was going on, and as soon as I turned around, a Dallas police vehicle was coming over the hill. And I just kind of handed it. I don't remember if I disconnected the call or handed it back to my wife, but said, hey, there's an officer here. I'm going to go talk to them.
So what'd you do?
Walked over, made contact with the officer, gave him a brief situation report on what was going on.
Did you tell him that you had actually held your weapon ready already?
Not there. Once we assessed the vehicles and we got them moved, I believe that's when that came up.
Did he bring it up or did you bring it up?
I don't recall which way that went. Because once we moved vehicles, once we assessed they were drivable and got over into a gas station, then he had other units coming over. Don't know if they were the actual dispatched units or if he called them, but then we started having a lot more people involved.
Dallas PD units?
Correct.
Did you know whether or not he called a supervisor to come out there?
He did at one point, yes.
Did a supervisor come?
Yes, I spoke with a sergeant.
Was it a sergeant?
I believe it was a sergeant. So it was a sergeant or a lieutenant, I can't recall right
Did
off.
you know why he was there? He was because the officer asked for a supervisor to come.
Right.
Would that be pretty standard procedure when you have a police officer, whether it's in your city or not, involved in a traffic accident?
If it was a regular accident, not so much, but due to the fact that this escalated to where it had to display a weapon, then it's always a good idea to have a supervisor come out and make any type of call that needs to be decided on.
Well, did you cooperate with the officers over there?
Oh, yes.
Did you tell them what occurred?
Yes, I did.
Did someone show up who you later learned was related to the people in the car?
Pretty soon after we moved from the street to the parking lot, her family arrived. Her dad and some other family members arrived.
What was the nature of, who was the dad talking to?
Dad was talking to DPD. I don't know if it was the officer that was initially arrived or the officer that was working the accident, and then also talked to the supervisor.
How long were you out there visiting with the patrol officers and the supervisor?
20, 30 minutes we were out there in the parking lot.
Did you ever tell them that you had other weapons in the car?
Yes, the father was alluding that...
Who was alluding?
The father.
Did you know it was her father?
One of the officers told me that it was her father. He was getting pretty heated. He was making some accusations about that I threatened to shoot them and I pointed the gun at them. I told the officer that was not correct, and I was having a lot of issues with her complying and following directions, but it was never pointed at her. And I described to him how I did it with the weapon, where it was placed, and using my hand. I did point at them, but I used my finger to point which one I'm talking to, whether it's passenger or whether it's driver.
So did you feel you had the authority at that point to give them instructions?
Yes. We have a duty to act. Law enforcement officers have a duty to act. We did not know what caused that wreck at that point in time, if it was a felonious act. Had they just committed a crime, they're having some type of argument, some type of domestic dispute, some type of issue, they dropped something, their distraction caused the wreck, or had been a civil mistake because she didn't know how to drive on wet roads because she was unlicensed, not trained properly. We don't know, but that reaction that I encountered immediately as I'm walking towards her vehicle about making accusations, that is not a normal state that I've ever experienced in my training.
Okay, so Dad was accusing you of doing what?
Accusing me of actually pointing the weapon at them and threatening to shoot them.
So did you go back to your truck and show the supervisor or any other Dallas officer the items that were in your truck?
Yes. I let the supervisor know, like, if I was acting in such that manner, look at what I have right here. Wouldn't I have used this instead? He just looks at it and goes, no. From what I remember, it was like, you have a good point, or you're right, or something along that line.
Well, so at that point, did you think they were questioning you as to, not about direct, but why you took your weapon out?
Right. It's not like they're just trying to do a fact gathering and they're going to do an incident report about the thing.
Did you cooperate with them doing an incident report?
Oh, completely.
What does your general orders require if you display a weapon at all?
Anytime we display a weapon, we need to notify our chain of command, or we have a form that needs to be filled out. Since I was off duty and did this, I immediately called my supervisor.
Who did you call?
My sergeant, my patrol sergeant.
That would be who?
Sergeant Snow.
And what did you tell him?
I informed him of the incident, what happened, where we're at. And I did this while we were in the parking lot of the gas station, so there was
Tell him that you had taken your off-duty weapon out of the holster?
Yes.
And what did you think he instructed you to do?
He told me he said, tomorrow, go in, write a memo for the lieutenant, that way we have everything documented.
Did you do that?
I did the following morning. I went in, typed in a memo, and not only just put it on the lieutenant's desk, but he happened to be in the office. So I personally handed it to him. He read it in my presence and said, okay.
And what did the Dallas supervisor say? Did you go home, or did they arrest you, or what?
No, there's no charges filed. There was no incident made. It was a fact-finding incident report done up just for records, the way it was explained to me.
Was that the entire incident?
That was it.
Well, Roy, you've been involved with this case since 2017. And you've seen all of this professional preparation that the district attorney's office has done towards taxpayer money, putting together all of this expert testimony. Knowing now everything that you know, if you'd have known all of this in that split second you made that decision, would you have made the same decision?
No, if I would have had all that information, no.
What are the things that could have prevented this whole incident from occurring?
I believe it was Mr. Hayden that said there was 9 seconds between the time that I retrieved the patrol rifle to the first shots. If any of those witnesses that I watched these past few days, if any of them would have been able to actually just step up, wave their arms, yell, hey, that's not the vehicle. If anyone would have intervened, it would have changed the outcome.
Well, if somebody had said, hey, the people that did the shooting are up on the hill and they're left on the yellow, what would you have done?
I would have yelled at Gross, gotten on the radio, and hey, that's not the vehicle. These witnesses are saying it's over there. It went that way.
Well, of course, you didn't really know if anybody got a vehicle involved. You were tracking Gross at that point.
Correct.
But if somebody had told you the people that did the shooting were in another vehicle and they left, what would you have done? How would you have told Gross that?
Yelled at him or gotten on the radio so he would have heard it and the incoming units would have heard it.
And what else could have prevented this horrible tragedy? Horrible happening.
If the driver just would have listened and stopped like he was driving.
Well, after you got over the shock and you were able to comprehend everything, what did you feel?
Sick to my stomach, heartbroken.
Cross-examination. Sir, I want to ask you several questions. And these are questions that you can answer with yes or no. If you need to explain your testimony, you can do that whenever it gets back on redirect. You agree to do that, sir?
To clarify, you're just wanting a yes, no, and no
These are
explanation?
going to be questions that all you'll have to do is answer yes or no. Okay? And then if you need to explain, you can do that on redirect. All right?
Okay.
Okay.
You're going to redirect also? I thought this was
Judge, I don't think he knows what we're doing.
If Mr. Lane gets the opportunity to ask you questions, that's what that means.
Okay.
All right. So you went in, as you just testified, the very next day, Monday, April 17, 2017, to Lieutenant Mark Merritt. You remember that?
Correct.
Okay. And there was no kind of internal affairs investigation.
No, there was
It was
not.
just because you pulled your guns, you had to let them know what happened, right?
Yes.
Okay. And you made a statement out on that?
Yes.
Was there anything in this statement about Ms. Arredondo or Ms. Cuevas yelling over in their car?
I don't recall.
Okay. I'm going to show you in a minute.
Okay.
Okay. And do you remember that you said in this statement, fearing that the driver was going to maneuver the vehicle in a way that would strike me, I removed my firearm from the holster and placed it against my chest with my right hand. Remember saying that?
Yes.
Okay? So you were afraid the driver was going to hit you, is what you told Lieutenant Merritt.
Correct. I believe that's what I said.
Okay? And does that sound kind of familiar as to this current case? Do you remember saying he was trying to hit you, to Officer Gross, immediately following?
Right, that's the third person. Right.
Okay. So those are exactly the same, right?
No, one's myself and one's my partner.
But it's a driver supposedly going to hit somebody.
One was a stationary vehicle, one was a moving vehicle.
But still,
could have
someone
been
trying to hit
maneuvered.
somebody with a car was your explanation, right?
One almost did, and one had the potential to. You're correct.
Okay. And you admit you pulled your gun,
Yes.
okay? And you'd already been home after getting off duty the night before, correct?
Correct.
Okay. And so you could have taken that rifle and secured it inside your house, isn't that right?
I could have if I was off on time or if I was in a hurry. You're
But
right.
instead you kept it in your truck, paraded it around over at Keys and Copper Hill, right?
Was not praying around, no. It never left the vehicle.
Okay. All right. So you go over there with the sergeant from the Dallas Police Department, and you point out to him your rifle, your Kevlar, and your flak jacket. Remember doing that?
Correct.
Okay? And let me tell you exactly what you said. You said, quote, it could have been a lot worse.
Right, in reply to the father's statements.
Okay? So you could have done the same thing to them that you did to poor Jordan Edwards. Is that what you're trying to say?
If I had that mentality or mindset,
You had the
anyone could
mentality to
have.
pull a gun while you're in your shorts and your t-shirt.
It was on me and the developed situation was deteriorating.
Showing you what's marked as State's Exhibit 286. You recognize that?
Yes, sir.
Your initials there?
Negative.
What initials are those?
That's a signature.
Okay, but it's your signature.
Yes, sir. I'm sorry.
So this is the statement that you made to Lieutenant Merritt today after you pulled the gun when you went.
That presented to him, correct.
You're all for State's Exhibit 286, Sean?
States 286 is admitted for all purposes. You may publish.
Do you remember that in your statement, you admit that Monique Arredondo told the police that you were pointing a gun at the people in the vehicle and that you said you were going to kill them all?
That is what the officer told me. So,
Okay, you deny that?
yes,
You do admit, however, that you did pull a gun on those two women after a fender bender,
correct. It was not a fender bender, but correct.
a traffic accident.
A collision,
Are
correct.
you in the habit of doing that?
Every situation is different, unique. I've been in many accidents before. There's no need for that.
You're familiar with Bald Springs use of force policy, correct?
Have a familiar, correct.
You know you're not allowed to shoot warning shots,
Correct.
so that's not what you were doing that night.
No.
You know that you're not allowed to attempt
Excuse me,
to...
did I need to orientate, that night, I don't know, you talking about the night of this shooting case or was it a stopping situation?
On the night of April 29, 2017.
Thank you for clarifying.
Okay. Were you shooting warning shots that night?
No, it's prohibited and it's not safe.
Were you trying to shoot the tires or the engine to disable the vehicle?
No.
Okay. And that's because you're not allowed to do that either.
Correct.
Okay. Were you trying to seriously injure or kill the driver of that car?
We were trying to, or I was trying to stop the threats on the vehicle,
Or were
correct?
you trying to kill or seriously injure the driver of that car with all out?
That was one of the threats, yes.
Okay. So yes is the answer to that?
Correct.
Okay. I mean, because there's no other reason to be pouring 5 shots into a car, is there?
I was not aware that it was 4 or 5 shots at that time.
Okay. You admit that you fired 5 times.
I was told I did, correct.
You know now that you fired into that car 5 times.
I've learned a lot more now than I did in that moment.
And so is that a yes?
Yes,
Okay. And so you meant to kill it all out.
I meant to stop and make whatever had to be done.
Okay. Either seriously injure him or kill him, correct?
Stop the threat, correct.
Okay. And you know that also part of your policy is because of the low probability of penetrating a vehicle with a handgun, officers threatened by an oncoming vehicle should attempt to move out of its path, if possible, instead of discharging a firearm at it or any of its occupants.
Correct, there was no handgun involved on my part.
Okay, so you think it's different with a rifle?
Going by the policy from what you've read, yes, sir.
And you know that the only time that you can conceivably shoot into a moving vehicle like that is if you're trying to use deadly force against the driver of the vehicle.
If it's being used in a deadly force situation.
So is that what you were trying to do?
Stop the threat, yes, sir.
Okay. Do you know all of the problems, reasons why you don't shoot at moving cars?
All of them? I don't think there's a way to know all of them.
Okay. Isn't it correct that you don't shoot at a moving car because you're wasting time that you could be getting out of the way?
Correct. I could be getting out of the way.
Isn't it true that it's very difficult to shoot the driver in a moving car?
That's a true statement.
Okay. And isn't it true that if you do happen to shoot the driver of a car, that then you've got an out-of-control car? Isn't that right?
You could, yes.
So that could actually make the situation even more dangerous. Is that right, Mr. Oliver?
Depending on the environment.
Okay. And isn't it true that when you shoot into a moving car or attempt to shoot into a moving car, run a very high risk of killing an innocent bystander?
That is a risk.
Okay. And in fact, that's in your TCOL training, isn't it?
I believe it is.
Okay. And isn't that exactly what happened here? You killed an innocent bystander in your zeal to kill the driver?
I'm not understanding the zeal.
Okay, in your decision to kill the driver.
Decision to stop the threat of the driver is what I'm correct.
By shooting into the car, you know what's going to happen when you shoot in there. And that's what you meant to do. That's what your policy says you got to mean to do.
Correct.
Okay, so you did it.
Correct.
You admit that you killed an innocent bystander?
He was a perceived threat at that time.
Perceived threat as a passenger in the car?
We were responding to gunshots to an active shooter. The car was being told to stop, being detained. The passenger was moving, making aberrant movements. Do not know what that passenger was trying to do or get.
Aberrant movements. You know, in your T-code frame, it says, quote, an officer should not use deadly force if there is a risk that an innocent person could be killed or injured. Do you agree with that?
Yes, sir.
Did you shoot this young man in the back of the head?
That's what I later discovered.
Did you?
That's what I later discovered, sir.
Some kind of off, so you'll either leave. Is that what you did, Mr. Alden?
That is what I learned that had happened.
Did you do that?
Yes, sir.
You see that Phantom bottle in there?
Yes, sir.
Okay. Remember poor Maxwell Everett thought that poor Jordan had simply spilled that all over himself?
I do recall
But
that.
that was about a gallon of blood, is what it was. Right? Is that
Yes, sir.
right?
Yes, sir.
Okay, so you're Roy Oliver, correct?
Correct.
And you admit that on April 29, 2017, you were on duty in the county of Dallas, state of Texas.
That's correct.
And you admit that you shot Jordan Edwards in the back of the head with a rifle.
Correct.
And you admit that a rifle is a deadly weapon. Is that right?
In the manner that it's used.
Yeah. Well, that's what certainly happened here, correct?
Correct.
John, we need to approach this time.
Mr. Snides approached the bench asking to, well, first of all, bring to the court's attention that you had filed, or handed over at least to the defense in January, which I don't believe is disputed, a 404B notice. Could you narrate for the record, if you still have it, who has the notice?
Judge, you do.
Well, they took it from me. All right, the notice says, Dow Worthington Gardens Deputy Chief Greg Petty saw a Facebook post from the defendant that said, I was placed on earth to kill. You attended that in January. I don't think that fact has been disputed. Is that right, Mr. Gill?
We received the 404B notice as you just dictated.
Okay. And Mr. Snipes essentially approached the bench asking to get into what they've listed as in their 404B notice. He's also got looks like a screenshot from a Facebook page, and he wants to get into cross-examination. Told the lawyers that I would hear their arguments. Mr. Snipes, the argument is?
It goes to the state of mind, Judge. It's fair cross-examination.
Oh, very good. And he will be replying on behalf of the defense.
Judge, just if we can memorialize what Mr. Snipes said over here, that they've had this image, I think, since December. This is in response. This is listed as an exhibit. We can mark it for this.
Hang on, I don't think he said he had the exhibit in December. Is that right?
That's correct, Judge.
You just got the exhibit. We'll mark it here this week.
Actually, first day of trial, Judge.
First a week ago. But you had information, I guess, from Dow Worthington Gardens Chief Greg Petty?
Yes, sir.
All right. So the information was given to the defense in January. The actual exhibit, which we need to mark. Mr. Hermes, would you please mark this since you're standing up? Ms. Wood, what number are we on?
For the state, I have no idea.
287. 287. 287 is the last.
So that'll be 287?
Yes, ma'am.
Thank you.
287 is going to be admitted for record purposes. Okay, so they want to get into 287 and cross-examination. He's made his offer of proof. Who wants to take this for the defense?
Judge, first let's talk about 287. They applied for a search warrant that I asked for at the first big break this morning, that the search warrant signed by you, it has this murder cause number on it, and it was under this heading in F1718595 in the 292nd Judicial District Court, where Buddy Evans applied for a search warrant on July 31st at approximately 3 o'clock in the afternoon or so.
Which year?
This year.
Okay.
So part of the rules of discovery, it's filed under this cause number. He applies for it. There is part of the application and affidavit for a warrant. They list a Facebook user ID as 10377322127. There is a Facebook URL, I believe, on the exhibit the state just put up there, and I don't believe it matches. So they have to start linking ownership of this. So as we go through stuff, we were given the disc originally by the state on the first day of trial, and the first assistant, on his word, gave us the disc and said he wouldn't be using this. You don't need to concern yourself about it. And as the week has progressed, the appointed district attorney has been sitting here showing a packet of this printout and others to people in the gallery, and sitting here in the courtroom talking about it during breaks. This is the document that's been the lead of about 10 pages in the courtroom. Okay? There's about 10 pages that Judge Snipes gave us as well, this being one of them from that. And this has been waved around and talked to and shown to people, talked about in the hallway with the media, that this was going to come up. The discovery that we were given on the disc is 4,000 pages. We've been in trial here, coming in the mornings, leaving the night, have had no chance to run this down and figure out the true source of this, because the URL that's on that exhibit doesn't come back to the URL that the state of Texas requested in their search warrant. So we have an issue there to begin with. Whether it's the handwritten notice, not a typed notice from the state of Texas, the first assistant, a handwritten notice on the 404B notice. It just, to say it doesn't smell right, Judge, is among other things. It just doesn't. We put them up. We've answered the stuff that's gone through. If they want to wait till the last second to sandbag us with the search warrant that should have been turned over, we asked for a return as well. They've yet to give us that today. And as soon as the records are back, the return should have been brought back to you to sign as soon as they got the records back. So, one, we don't have all of our information under Michael Morton still to comply. Now we're faced with it in trial where we have no choice but to go forward with our side of the defense, and we've been put at a distinct disadvantage based on the timeliness of discovery, which hasn't been in this case, by sandbagging us and by going back on a person's word as an officer of the court that they weren't going into it. It's a police shooting case. Chances are the officer's going to testify. They didn't have to come over and say that, but they did. And that's just not right. So if there's any equity in a courtroom nowadays, that's not right when somebody goes back on their word like that. And to be brandishing and waving around the courtroom just isn't right either. And they've been doing that. So we have a document here that's part of 4,000 pages. They haven't laid the authenticity or the predicate to prove that that's the actual document, that this undisclosed officer that's listed in the affidavit that you saw on July 31st can even link the two up. We'd ask to have our full motion to suppress so they can prove this up and go through it. Our objection would be under 403 that it didn't, the probative value is substantially outweighed by how bad it is, Judge. The prejudicial effect is going to cause problems here. I don't think the defendant's state of mind has been put in issue. He's admitted everything that's been asked on direct and everything that's been asked so far on cross. Be happy to file a motion to suppress and make it oral based on the Constitution and walk through it. I think it's a constitutional motion to suppress because it's records that they're going to claim it's of the defendant. We have a staleness issue that has to be considered too. If their affidavit is believed to be true, the warrant itself was not written until July 31st, and based on their own affidavit, the records were stood down in April of last year. And that puts us into a case, U.S. v. Flores, decided September 23rd, 2015, 802 Fed 3rd, 1028. I apologize that it's a Ninth Circuit case, but that's where Facebook is, where they talk about the determining factors a court has to make whether a search warrant for records that are old have met and passed the staleness test along with other tests as we go through and look at an affidavit and search warrant.
To overrule the defense's objection, you're allowed to cross-examine the witness about the contents of 287. To me, that's a prior statement, and you can examine the witness whether he made it or not. And if he denies the existence of that statement, and you want to prove it up later, then you might run into some trouble by presenting extraneous conduct. But I do find that the state gave proper notice under 404B back in January at least of this particular statement that was made extensively to Greg Petty. So I'm going to allow you to do that. I'll give you a running objection. 287 is admitted for record purposes only at this time. Is there anything else?
Yes, Your Honor. May we cover up if the photo itself is the issue, can we cover up all the other hearsay that's on the document, whether it says Facebook records and stuff like that? If the photo's the issue, then we'd ask the court to segregate the photo out and everything else is hearsay because they can't prove up the hearsay at this point.
287 is not admissible unless he denies the existence of the statement, and then in proving the extrinsic evidence of denying the existence of the statement, we can address those issues. But as it stands right now, 287 itself is not admissible, but he's allowed to examine the witness under 609, like possibility of the prior statement that he made.
And Judge, under Michael Morton, can you please instruct the state to provide the return of the search warrant?
You have the return of the search warrant?
I will attempt to find it, Judge.
Okay. And then
Gave more found.
and now, let me ask this, are there any other statements that you had given notice of, that you're aware of, and those other, let's say, 3,999 pages? Have you given notice of any other statements in your notice to Mr. Doucette?
No, sir. This is the one that Chief Petty saw.
Understood.
And Judge, while we're on this extraneous offense, when we were in court for the hearing before trial started, First Assistant Snipes, it was revealed by one of the victims in those cases, was told 10 days before the trial started that that witness, a victim, could not identify the defendant, and we've yet to receive the formal Brady notice on that. If that's going to come forth as well, we'd like that.
Okay, I'll take that up later. I need to get the jury going. Please remember to remind me of that. And Sheriff, call the jury.
Your Honor, may we just briefly ask the court. It's our intention at this point here, the defendant has put in issue several matters. Most, I think, particular for what I'm about to argue is he said during direct examination that one of the reasons why he was picked for this security detachment that he went on for quite some time about was because he was good at interacting with individuals. This was generally what was known of him. I think that he's put that representation in front of the jury, not only with that direct statement, but through the tenor of his entire examination. I think that in addition, this is cross-examination, his credibility, his character is an issue as far as in front of this jury. We have a number of other issues that we've given defense notice of, one involving a gentleman that Mr. Oliver arrested where we believe excessive force was used. That's listed in our extraneous information. Also, there was a situation involving the district attorney's office many years ago where a district attorney in a workroom actually felt threatened by Officer Oliver in his conduct, thought that his demeanor and his behavior was excessive and frightening. I think the door has been open to all of these. I think the state is entitled to clear up that misrepresentation. We'd like to go ahead and get into, at the very least, cross-examining Officer Oliver on all of those matters. He's put these into place, sir. He's put the cards on the table.
All right. Y'all can have a seat. The 404B notice that I've gotten, that I was able to find on base, and y'all know that I'm not a big fan of the county system. The first one was the Arredondo Guerrero incident, and that's coming. The second was an incident involving a prosecutor named Leighton D'Antoni.
That's what I'm referring to, Your Honor.
All right. I don't believe that's relevant. There was another one about And I'm going straight off your 404B. Caucasians in effect. And you're offering, are you seeking to get into that as well?
No.
Okay. The next one I have is a psychological examination that revealed that the defendant made certain statements. Are you seeking to get into that?
Yes.
Okay, that's on here. Let's go one at a time. Mr. Gill or Mr. Brissett or Mr. Lane, we're seeking to get into, I believe it was item number 4, one of the bullet points about psychological examination that was done. Their notice of extraneous that they tendered back some months ago. You know what I'm referring to?
I didn't hear them say they wanted to get into that, Judge.
They just did. I just asked them, they said they wanted to get into that.
Well, the reason they have advanced for getting into these things is credibility, and none of those things are credibility. They're extraneous acts that don't involve credibility issues.
Judge, I also said, if I may, that he represented that he is good at interacting with people, and that was the reason for this big promotion. He testified to it, Judge, just a few minutes ago in front of this jury.
I understand. I recall his testimony.
Yeah, so
tell me
that's...
what it is. Mr.
He said there was
Hang
something
on,
else.
one at a time, please. Mr. Herman, what I'm asking you, you've got certain things that are listed in your 404B.
Right.
I'm going straight down the list. Tell me what you want to get into and what you don't. I'll make a rule. The next thing I have in front of me is the psychological examination. One of them is a statement that is attributed to the defendant, where he says, I am uninhibited and immune from threats. Are you seeking to get into that?
Yes, sir.
Okay. And another one is a doctor's opinion that you all put in your notice that says, in the doctor's opinion, the actions of the defendant he may not care what others think. His antisocial behavior is possible. Are you seeking to get into the doctor's opinion?
Yes.
Okay. All right. And those are the only two that I have. Mr. Gill, do you have any response to that? We're going to go one at a time.
I'm still not exactly sure what they're trying to get into. So I apologize.
That's okay. There's a 404B notice that's on file.
Yes, sir.
I'm going straight down their list. I believe it was filed sometime in November of 2017. And there may be others, but I'm going to take them one at a time. The first incident they have on there is the Arredondo Guerrero incident that y'all got into without any prompting from the court. The second one is an incident with a prosecutor named Layden D'Antoni. I don't believe that that's wrong. Then there's this Caucasians in effect. Y'all are not seeking to get into that at this time. The next one that I have is the psychological examination that was done in 2011, as I recall. One of them, which y'all sought to get into, was statements that were made by the defendant, which to me are fair game. There's another one where there's statements that are put in your notice from a doctor. The doctor's opinion that he's prone to antisocial behavior. With this witness, I'm not going to let you get into what the doctor thinks. I will let you get into the statement unless I hear a good objection from Mr. Gill.
Doctor's statement?
The defendant's own statement that the way it was represented in the 404B notice was, I am uninhibited and immune from threat.
No, Judge, I need to correct that. If that's the way the notice reads, that's, I think, believe the doctor's impression.
Right. Pretended to describe himself.
Okay, Judge.
So, is your 404B notice wrong or right?
It seems to be right.
It's correct.
Okay, so if you have statements that are attributed to the defendant, I'll let you get into that unless I hear a good objection from Mr. Lane.
Well, if that was what the doctor was, in a report that's required to be done by TICO, prior to the time him certifying him to be fit to be a Texas peace officer. Well, it wasn't attributed to him. I think that was the doctor's opinion.
Do y'all have the report?
Yes.
You've got it, Judge. I gave it to you for continual review, and it says clearly, defendant described himself as uninhibited and immune to threat.
But that was the doctor's opinion.
No.
Defendant described himself.
I got it. I recall it. It was a statement attributed to the defendant, so I'm going to let the state get into that. As I recall, on that November notice, and that was the last 404B extraneous matter that you sought to get into. Have there since been others that have been filed? I didn't get a copy of your handwritten motion.
Yes, sir. specifically an incident in which he used excessive force against Luis Medina.
In his capacity as a Gulf Springs officer, a police officer?
Yes, sir.
Very good. Any reply to that, Mr. Gill, Mr. Lane?
Your Honor, just for point of clarification, so I can look in the notebook, what date is the file stamp on the state's copy of that?
Right this moment, I don't have that, Judge. I can get it here.
Okay. Well, that's fine then. But if it is as he represents, do you know the incident that he's talking about? An excessive force that was used? What's the witness's name?
It all depends on how the notice was given to us.
Louis Medina.
And I'm having a hard time keeping track of these different incidents that they're proffering and the reasons that they feel like they're admissible. And that's all important because at some point we're going to be asking the court to draft a limiting instruction. And the law entitles us to know, as we're answering, first of all, the proffer, and then preparing the limiting instruction, just exactly what reason it is they're proffering this, because they have to provide to the court something aside from character conformity to admit it.
Besides the Luis Medina incident, is there another one?
No, sir.
Okay.
Judge, while we're waiting on that, can I make an argument that might persuade you otherwise on the D'Antoni thing?
Sure.
Okay. So, Judge, I think that the door has been opened and misrepresentation laid by the defendant's testimony in two regards. Number one, as I've said twice, his claim that he interacts well with others. That's him essentially affirming a good character in front of this jury. Secondly, he testified under a number of times about compliance with rules, following general orders, absolutely critical. He had testified and alluded to that many times. When he was asked about going to the scene on Bishop, he said he was doing so only because he was ordered to do so. So he's given the impression that following orders, following policy is very important to him. That is in front of this jury. What he did on that particular day in question is he came in, he didn't follow orders. Matter of fact, he was reprimanded for leaving. He was reprimanded for, I think, you know.
I'm sorry. Reprimanded by who? I don't know.
Okay, well, he was reprimanded by his own department because he was reprimanded by suspension from his own department for leaving court without permission over the objection of prosecutors. During his testimony in court, he used expletives that caused the judge to be very concerned about his mindset. Again, going completely against following the rules, showing up at court when he was ordered to do so. As he's walking out of the workroom in the middle of trial, the prosecutor instructs him to return, and he absolutely refuses to do so. It wasn't until supervisors.
So you've got a violation of an order and a suspension from his office.
Yes, sir.
Was there, you got excessive force, you used the word excessive force, this Luis Medina incident.
Yes,
Was
sir.
there a violation that he was sustained against him for this?
No, I don't believe that was investigated.
When you say that it was excessive force used against Luis Medina, tell me what you intend to prove. What's the testimony?
Witnesses are going to say that he slammed Luis Medina's head against the floor, choked him out, said words to the effect of, well, he can still breathe, something along those lines. And I've got 3 witnesses that will all say that.
What was there he was found suspended? Was he reprimanded? Was there a policy violation that was sustained against him or anything that you know about?
No, sir.
Okay. Mr. Snipes?
Yes, sir.
If I allowed you to get into Lewis Medina, tell me what happened. A nutshell version of what happened.
Right. The younger child had, from time to time, epileptic fits. So the family called 911. The defendant and another officer arrived while he was still having epileptic fits. And the defendant and his partner basically forced Medina Jr. to the ground, choked on him, with daughters complaining, saying, he can't, you're choking him. And he said something to the effect of, he can still breathe. And then there was a banging of the head against the wall. 3 witnesses. And all I want to do now is cross-examine the judge.
We're waiting on a copy of the 404B. Is that?
Yes, sir. Judge, off the record, I only see one in November. Have you seen that in the context? I'm just trying to,
That's the one that I saw.
okay, just, unless I'm missing something, how do you see stuff? I'm just trying to figure out where we're lining everything up. Jason, do you have your list of stuff? There's Andy down here. You can check the list of what those are, so I can line up these shingles and some
Are you talking about the base stamp document?
Not the base stamp, I'm trying to figure out what the other one is. Is that the Dana one?
I'm actually, mine is only published. The only thing we're waiting on is this Luis Medina, the notice on that, that's it?
Yes, sir.
Okay, all right, let's go back on the record. There was a policy violation. The only thing we're waiting on is this Luis Medina, the notice on that, that's it?
Yes, sir.
Okay, all right, let's go back on the record. Now that I know that there was a policy violation in this Leighton D'Antoni incident, Mr. Gill and Mr. Lane, whoever's going to be responding to this, do you have any reply to the state's offer that they want to get into, showing that Officer Oliver violated policy in court through Leighton D'Antoni in this exchange that led to a policy violation being sustained against them? You all want to be heard on that?
I'd like to know what is being offered for.
I think he's saying, go ahead, Mr. Henry.
Judge, again, it deals with his misrepresentation of good interaction, good reputation, good character, number one. Number two, multiple instances of testimony where he indicated compliance with rules, following rules, policies, and general orders specifically.
Okay. We're making that offer, Mr. Gill.
Following orders. Policy. Character. What particular character trait are we talking about? Just, that's what I'm not understanding. What, I mean, they keep saying it's for his character, but they don't, we're not talking about, I've not heard a specific character trait that they're seeking to offer to something.
The character trait of following rules, abiding by rules, orders, general orders, and policies.
Go ahead, Mr. Gill.
All he has testified to so far is that when he has been specifically asked about an event, he has said that he followed that particular rule. He's not made a general blanket statement that he's a rule follower or never fails to follow rules. He has not put that specific trait in issue. He's only responded to a discrete number of specific instances where he said he has followed a particular rule as told to him at that time.
Right. The objection is going to be overruled by how you get into the incident with Mr. D'Antoni, changing my ruling on that.
We request a limiting instruction on that, Judge.
Okay?
We also object under Rule 403, and its probative value is substantially outweighed by its prejudicial effect. It's misleading, it's confusing, and it's going to be a needless consumption of time in front of this jury.
Okay. That objection is overruled as well. The next one is a psychological examination To the extent that there are statements that are attributable to the defendant, I'm going to let the state go into that. Over your objection.
Do we have our 403 objection on that also, Judge?
Yes, sir. That's overruled.
Thank you. And we have a limiting instruction.
Yes, sir. And the next one that I have on my list is this excessive force that was, the term was used by Mr. Herman, Mr. Snipes. I don't find that to be relevant at this point in time. So is there anything else, any other reason why we can't bring the jurors back?
No, sir. Thank
Mr.
you.
Beal?
Can I hear the limiting instruction you intend to give?
This is what I'm going to read to the jury. This is what I'm going to read to the jury. This is your limiting instruction. You are instructed that certain evidence was admitted before you or will be admitted before you in regard to the defendant having committed offenses, if any, other than the one for which he is now on trial. Such evidence cannot be considered by you against the defendant as any evidence of guilt in this case. Said evidence was admitted before you for the purpose of aiding you, if it does aid you, in testing the credibility or determining credibility of the defendant regarding the defendant's character and his state of mind. You have any objections other than me doing this at all?
Yes, Judge, rather than calling them offenses, it's really if it's anything, it's conduct, which of course also falls under Rule 404. It's either an act or it's conduct. It's not an offense.
Well, it would be a crime, wrong, or other act. Let's go to 404B.
Other act.
What do y'all want?
That's fine.
We're good with that.
Having committed other acts if there's not.
And it's your finding that they're admitted on the issue of his credibility and his state of mind?
Yes, sir. And to rebut a defensive theory.
We further ask that the jury be instructed before they can consider that testimony for any reason they must believe beyond a reasonable doubt that it's in fact true.
All right. Anything else?
That's it.
Thank you, sir. Call the jury.
Judge, you okay if I sit down?
Thank you.
So why would I do see you without a time or coat?
Does that equal donuts? Like donut bowls?
Should be. Mr. Harris would be. Mr. Harris dressed like a lawyer.
Nice tie. Are you going to take a direction?
Go ahead.
I wonder what oh, wait. They're all home. Okay.
Don't pick on you, Jordan. Don't pick on you.
Go ahead, Sheriff.
All rise.
Thank you, Sheriff. You all may be seated. Members of the jury, first of all, thank you for your patience. While you were out, the court made certain rulings, and I'm going to give you the following instruction. Please listen carefully. Something similar will also be contained in your jury charge, so please be mindful of that as well. You were instructed that certain evidence is about to be admitted before you in these cases in regard to the defendant having committed other acts, if any were committed, other than one for which he is now on trial in all three of these cases. Such evidence cannot be considered by you against this defendant unless first you believe it beyond a reasonable doubt, and secondly, only if you believe it beyond a reasonable doubt, understand that it cannot be used against the defendant as any evidence of guilt in this case. Said evidence will be admitted before you for the sole purpose of aiding you, if it does aid you, in testing and determining the credibility of the defendant regarding the defendant's character, the defendant's state of mind, or to rebut a defensive theory. Mr. Snipes, you may continue your examination.
One of your bosses at Dow Williamson Gardens was Deputy Chief named Petty. Remember that? Greg Petty?
I remember Greg Petty was not one of my bosses. Sorry.
Do you remember that on July the 12th, 2013, you made a Facebook post that was read by Greg Petty that said, quote, "I will never in my life be as good at anything else as I am at killing people," end quote.
That was a repost. That's correct.
Okay. You made the post.
I reposted, correct.
Okay. We offer 287, Jeff.
Any objections? That's exactly what they said they weren't going to offer. All right, 287, I'm going to hit it for record purposes only this time.
And do you remember having a psychological assessment on July the 1st, 2011 in order to get employment at Balch Springs?
Yes.
And do you remember that you told the psychologist that was examining you described yourself as uninhibited and immune to threat? Do you remember that?
No, don't speak in that manner. Psychological tests, you're given different options to choose from as what describes yourself, and that's probably what I picked, but using those exact words would not be my vocabulary.
Do you agree with that assessment?
If that was between the options, I'm sure that's why I selected it, depending on what the other option might have been.
Do you agree that you're uninhibited and immune to threat?
Not completely immune to threat, no one knows.
Do you remember being disciplined in the latter part of 2013 for your behavior down in this very courtroom, not courtroom, courthouse?
Yes.
Okay? And do you remember that part of the reason that you were disciplined was that in front of a jury, just like these ladies and gentlemen over here, in front of them, you said, quote, "I don't remember the fucking question," end quote?
That is correct.
Did you say that?
Yes, sir. I just admitted
Okay.
that.
And then did you frighten a bunch of assistant district attorneys with your conduct?
I don't know how they felt. I did get confrontational with them over the comments they made.
And were you in fact suspended as a result of this?
3 days, correct.
Okay. And did you use profanity to these assistant district attorneys and also a young intern named Sarah Stefaniak?
Towards the two DAs that I had the confrontation with, yes.
And you admitted all of that to your chief at the time, Chief Morris.
Oh, yes. There's no denying the incident.
Now, when you talked to Officer Gross immediately following killing Jordan Evans, you said, "You all right?" And he goes, "Yeah, I'm fine." And then you said they were trying to hit you. Does that sound familiar?
That's what I saw in the video.
Did you say anything at that time or ever that night with regard to how you thought maybe that there had been gunfire from the back of that car?
Not out there on scene.
Okay. Did you say anything about how you felt in fear for yourself?
No. Not that I recall.
And you saw the testimony of Grant Fredericks and you've seen the body cams, correct?
Correct.
And so you know that all 5 of the shots that were fired by you on the night of April 29th were fired after the Chevrolet Impala had passed by Officer Gross. You know that?
That's been correct. I learned that.
Okay. You've seen that evidence.
Correct. I learned that from the evidence.
Okay. And do you know that your shots 3, 4, and 5, all of which could have hit any of those kids, and only by the grace of God didn't, were shot at an angle approximately 45 degrees to the southeast after that car had passed you, Mr. Oliver?
That's what I learned.
Okay. Now, you also say on your body cams, I believe to Sergeant Snow, words to the effect of, "We were both giving them commands." You remember saying that?
I saw that in review. I really thought I was yelling commands.
But you weren't, were you?
And after I reviewed it, no, I think I was in such fear of my partner being hit that I couldn't verbally get anything out of that shock with what the situation was developing to.
Okay. Isn't it true that you were just trying to bolster your position to Sergeant Snow? That's why you said we were giving them commands, when that's totally untrue.
No, I really thought I had.
And you admit that you went down to Bishop, where there's 4 kids were being dragged out of that car, and you admit that you went in and took vital signs on Jordan Edwards.
I don't recall kids being dragged out of the car.
Well, do you admit that you took Jordan Edwards' vital signs?
I checked for a pulse and a sternum organ.
And you know, you were an experienced law enforcement officer as of that night, is that right?
Correct.
So you knew you could have gunpowder residue on you?
I'm not disputing that, no.
Okay. And you rubbed it on him anyway?
Not intentionally, I'm trying to check if there are signs of life.
Were you familiar with the response that you and your lawyers made in a civil case pertaining to this case?
Vaguely, it's been a long time.
Okay. Did you know that that civil response accuses these poor children of being drug dealers, gang members, and having guns in the car?
I never stated that.
Your lawsuit says that.
Like I said, I've worked as a civil attorney. I'm really not sure where that information came
So
from.
you never even read anything that was in the response to that lawsuit before your civil lawyer filed it, accusing these kids of being gang members, drug dealers, and having guns in the car?
I never stated that. I never saw inside the car, except for when I checked the files.
Okay. Your response says that.
I'll take your word on that.
Okay. And you know that that couldn't possibly be further from the truth. Isn't that right, Mr. Oliver?
I know that now, after witnessing all this and what we've learned over this past week.
Did you have any grounds whatsoever for making those spurious allegations?
I don't recall personally making those allegations.
Your lawyers did.
Maybe they. I believe you.
Did you know about that?
No. I remember reading quite a few drafts. I don't remember that in particular.
You said that you felt sick to your stomach after you realized what you'd done. Remember telling them that?
Yes, anytime you're put in a situation, if you take a life, it's not something that happens easily by any means.
Were you sick to your stomach and feeling bad when you told Officer Pedro Gonzalez that Officer Chamblee was being a dick?
I was in shock over the situation and the way Chamblee was acting at that point in time.
And you were so remorseful and felt so bad that at approximately 8 minutes and 30 seconds into Officer's dash cam, you yell at poor Vidal Allen, quote, "All directions." Remember that?
Yes, he felt to comply with Officer Gross, and he felt to comply with what Officer Chandler was telling him. I didn't use any salty language. It was just straight matter, follow directions.
These folks have seen that dash cam. Does it look to you on that? You've seen it too. Like Vidal Allen was trying to be defiant and not follow directions?
Never said defiant, but if he was following the actual directions that Officer Chandler was giving him word by word, then I wouldn't feel bad.
Do you remember him saying, "Please don't hurt me, please don't hurt me"?
Yes.
And you follow that up with "Follow directions."
If he was trying to turn around, if he was not following or going in a different direction as ordered, then yes, I would feel bad.
And you admit now that you shot an innocent 15-year-old 9th grade student. You shot him in the back of the head.
Knowing the information we know now and everything that's come out, yes.
You admit that he's innocent.
Knowing what we know now,
Do you remember saying on either your body cam or Gross's that you made those kids go through the mud, quote, just to have some fun back over at Barron? You remember that?
we were out talking with the kids, having a good time with them. And yeah, I stated that. If they wanted to go around me, I did let a few go around me. I didn't force them to do mud. I gave them other options around.
Okay. Do you remember, this is a quote from you, I made them go through it just to have some fun.
I didn't force them through it, but yes, I was encouraging them to go that way.
Did you use those words, made them go through it just to have some fun?
I don't remember the exact words, but I remember something along that line.
Okay, what's in evidence? And then, during your testimony, you said that you thought that the Doll Allen Chevrolet Impala might have been about to clip Officer Gross. You remember that?
Yes.
Okay. If he's clipped like that, are you trying to tell them that that means that they were trying to kill him and that you felt like you had to shoot to protect him? To kill? Shoot to kill?
Shoot to stop the threat. Could be clipped, could be put underneath the tires, sent through the air. A motor vehicle moving at someone can cause some damage, possibly death.
You're running up that hill, and at 11:18:28 is when you start running. And you fire your 5 shots at 11:18:37. So you got 9 seconds to decide whether or not you're going to shoot that rifle. Isn't that right, sir?
You'll have 9 seconds.
Did you pull that rifle up to your shoulder, make the decision to fire before you even got up there? Did you fire 3 perpendicular shots, 2 perpendicular shots after that car had already passed Officer Gross and you couldn't possibly have done anything to him?
I don't remember where the shots were actually fired in my perspective, but from the evidence that you have showed me, then that's what I've learned.
First 2 perpendicular after cars passed Officer Gross. And the last 3 after that car has actually even passed you. You remember that, sir?
That's what I've learned.
And all of those shots, only but for the grace of God, do we not have 5 dead kids on our hands. You understand that?
Yes, sir.
I pass it to the judge.
Roy, it's been offered into evidence, the general orders that you have out there at Ball Springs. And Mr. Snipes read so far, but they're in evidence. It's dealing with the deadly force restrictions. And Dr. Hayden confirmed that this was an order that was recertified, restamped, and reissued on February 2017. Remember that?
Yes, I do.
And your general orders are the orders that supposedly guide your department, correct?
Correct.
And the general orders deal with not firing a handgun into a moving vehicle because instead of discharging a firearm at it or any other occupant, it's difficult to stop a vehicle or threat with a handgun, right?
This is true.
But the rest of the order is at least the order that you're working under out there says, however, if an officer reasonably believes that a person is immediately threatening the officer or another person with deadly force, which would be the vehicle, by means of the vehicle, an officer may use deadly force against the driver of the vehicle. Correct?
This is correct.
Well, following that general order, not that you are obligated to go out and indiscriminately shoot at people in the vehicle. But I mean, is that what you did? Fire at the driver of the vehicle that was threatening another person with deadly force?
That is correct.
Did you think your general orders gave at least you that leeway to do that as long as it was reasonable?
I did.
Do you think what you did there that night, as far as you understand what reasonable is under these circumstances, it was reasonable?
Under these circumstances, in that situation, I did.
Let me ask you about the things that Mr. Snipes was talking about. I guess the officer, Teddy, is that his name? What's the officer?
Teddy.
I don't know what a repost is. What is a repost?
Someone posts something on a wall or a board, big into the veterans community, veterans awareness. Due to high suicide rate in veterans, it's important that we look out for each other, communicate with each other. And it was something that one of those veterans had posted, and I was reposting it just to get it out there for conversation.
Well, you understand that it's talking about whoever sent it and created. You didn't create that document.
No, I'm not creating names or stuff.
The courthouse situation down here, there's a little bit more to that story than what Mr. Snipes talking about.
There's quite a bit more.
How long had you worked before they asked you to come down here and testify to the that trial?
I'd worked a 12-hour shift prior to.
What time did you get off?
6
In the morning.
Correct.
What time did the liaison from the Dallas Police Department to the Ball Springs and the Dallas DA's office and the Ball Springs Police Department have you to appear here at this courthouse?
Sometimes they'd have us come in at 9, sometimes 10 o'clock. It just kind of varied depending on the courtroom, what time they wanted us to report for duty for the court.
Well, do you remember what time you were to appear that day?
I can't remember if that one was a 9 o'clock showing or a 10 o'clock showing.
Well, what does that do to an officer that's been up all night, and would you have had to call the police department, have you to appear here at this courthouse?
Sometimes they'd have us come in at 9, sometimes 10 o'clock. It just kind of varied depending on the courtroom, what time they wanted us to report for duty for the court.
Well, do you remember what time you were to appear that day?
I can't remember if that one was a 9 o'clock showing or a 10 o'clock showing.
Well, what does that do to an officer that's been up all night, and would you have had to come back on duty again at 6 o'clock that night?
That's make you very tired. We worked a 12-hour shift, and then we're coming up to testify in court, and you don't know how long that's going to last, and you've got to go back and work another 12-hour shift afterwards.
Well, what was the comment from this Dallas DA's office that caused you to get upset?
Officer Chamberlain and I both worked a 12-hour shift, and then we were going to be going back for a 12-hour shift. I asked if we could have it reset to a day that we were off due to officer safety. You want us to go out and make split-second decisions on regular vehicle and then have virtually no sleep. I said it wasn't safe. The ADA, Assistant District Attorney, informed me that he didn't care about officer safety. I can't remember if he said concerned about the wind or concerned about the conviction. And I took that very personal, being it's important for Chamberlain and I to be safe in what we're doing and translate to being safe to the community.
You agree with your department that you acted out of line?
I did. I take responsibility for my actions. I didn't deny it. I informed my supervisor of the incident that night when I reported for work, and the chief was also notified.
Do you remember who was supervising those assistant DAs?
I believe it was Columbus.
And you took it as an offense to officer safety?
Yes.
The doctor, or the quote that they're attributing to you about having, I don't remember the exact words, that came from a psychological examination.
Yes.
That people required.
Correct.
And the doctor that responds to us has to tell the people of the state of Texas and the police association, the police force, whoever you're going to try to go to work for, whether or not you met the standards for a police officer.
Correct.
How many times did that doctor certify you as being an individual after testing was qualified to be a law officer in Texas?
He certified me twice for law enforcement, and the very first time for firefighting. I'd actually taken 3 psychological exams through this psychologist.
That's all. Just saying.
Nothing, sir.
Very good. Sir, you may stand down.